Highbridge, a division of Recorded Books, presents Making the Supreme Court, The Politics of Appointments, 1930 through 2020, by Charles M. Cameron and Jonathan P. Kastellec. Read by Lee Goettl. Publisher's Note: in this audio edition, you will hear references to figures, tables, and equations present in the print and e-book formats of the book. We have created a website for the book, makingthesupremecourt.com, that contains the appendix to the book, as well as replication data and code for all the analyses that appear in the book. Part 1. What happened? 1. Then and now. He, the President, shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. U.S. Constitution, Article 2, Section 2. On January 31, 1941, James McReynolds announced his retirement as an Associate Justice of the Supreme Court. McReynolds, appointed by President Woodrow Wilson in 1914, was one of the notorious Four Horsemen, a block of justices who consistently voted to strike down as unconstitutional President Franklin Roosevelt's New Deal measures between 1933 and 1937. Although the court would eventually endorse the New Deal in full in 1937, McReynolds continued to oppose it until the bitter end of his tenure on the bench. McReynolds' retirement granted Roosevelt, now in his third presidential term, his sixth Supreme Court appointment. During his first term, Roosevelt had no opportunity to alter the court's membership and end the reign of the Four Horsemen. Following his landslide re-election in 1936, Roosevelt proposed court packing, increasing the number of justices to give a favorable majority, as a way to break the logjam. While Congress soundly rejected the court packing plan, Roosevelt ultimately prevailed, as a majority of the court dropped its opposition to the New Deal that year. Then, a combination of 5 retirements and deaths between 1937 and 1940 granted Roosevelt the opportunity to greatly reshape the court. A few months after McReynolds' announcement, Chief Justice Charles Evans Hughes announced his retirement as well. Roosevelt now had the rare opportunity to select a new chief and simultaneously replace an associate justice. The master politician eagerly grasped the chance, converting it into a triple play. First, he nominated sitting Justice Harlan F. Stone to replace Hughes as Chief Justice. Then he nominated Senator James Burns, a strong New Dealer who had supported court packing, to replace McReynolds. Finally, he nominated his Attorney General, Robert Jackson, to replace Stone as Associate Justice. In one stroke, the triple play replaced 22% of the court's membership and produced a much friendlier Chief Justice. Roosevelt officially submitted all 3 nominations to the Senate on June 12, 1941. Democrats overwhelmingly controlled the 77th Senate and saw eye to eye with the President on judicial matters. Nevertheless, one might have expected the august body to review the 3 appointments with a degree of due diligence. For example, Burns, a power broker in the Democratic Party, had enjoyed a long and distinguished career as a House member and senator from South Carolina, but he never attended law school, nor practiced at the Supreme Court bar. Such diligence would not come due, however. The Senate confirmed Burns on the same day it received his nomination. The Senate's reviews of Stone and Jackson were only slightly less perfunctory. Unlike Burns, both were referred to the Senate Judiciary Committee for a hearing, but the hearing was brief, and the Senate quickly confirmed both nominees by voice vote, with not even a single dissent sounded against them. Within a span of 5 years, Roosevelt had appointed an astounding 8 justices. The court that had so famously frustrated the president would no longer pose any obstacle to his agenda. 75 years later, things look quite different. In February 2016, Justice Antonin Scalia died suddenly while on a hunting trip. Scalia's death created an unexpected opportunity for President Barack Obama in his last year in office, to make a third appointment to the court. The Senate had confirmed his first two appointments, Sonia Sotomayor and Elena Kagan, with minimal fuss in 2009 and 2010 respectively. But Democrats overwhelmingly controlled the Senate in those years. Although fewer than 10 Republican senators voted yea on either nominee, the GOP's opposition did little to impede Sotomayor and Kagan's smooth paths to confirmation. The political landscape in 2016 was quite different, however. The 2014 midterm elections placed Republicans in control of the Senate. Within mere hours of Scalia's death, the new Senate Majority Leader, Mitch McConnell of Kentucky, threw down the gauntlet, stating in a press release that Senate Republicans had no intention of filling the vacancy before the inauguration of the next president in 2017. A month later, President Obama nominated Merrick Garland, a widely respected judge on the U.S. Court of Appeals for the D.C. Circuit, to replace Scalia. In 2009 and 2010, Obama had placed Garland on the short list of candidates for the vacant seats, but he passed over Garland in favor of Sotomayor and Kagan, purportedly to save him for a possible future appointment under divided party government. Indeed, relative to the larger pool of potential Democratic nominees, Garland was noticeably less liberal and also somewhat older than a typical modern nominee. In fact, in 2010, Senator Orrin Hatch, a Republican and a former chair of the Senate Judiciary Committee, had urged Obama to nominate Garland to replace Justice John Paul Stevens, stating that Garland would be a consensus nominee and confirmed with broad bipartisan support. 6 years later, however, Obama's selection of Garland met a brick wall. Under McConnell's leadership, the Senate took no action on Garland's nomination. The Judiciary Committee held no hearings, and no floor vote was ever scheduled. Though some nominees prior to the Civil War, and then again during Reconstruction and the late 19th century, were rejected quite summarily by the Senate, the tactic of refusing to take any action on a Supreme Court nominee appears to be unprecedented. 9 months after Scalia's death, and 8 months after Garland's nomination, Donald Trump shockingly upset Hillary Clinton in the 2016 presidential election, thereby dooming the already slim prospects of a Garland confirmation in the lame duck period. Garland's nomination would end with no bang, and barely a whimper, on January 3, 2017, the day the 114th Congress officially ended. The successful deep-sixing of Garland gave Trump the rare opportunity to enter office with the Supreme Court vacancy in hand. Trump had invoked the vacancy as a campaign issue, pledging to appoint conservative justices in Scalia's mold. He even took the unprecedented step of publicizing during the campaign a list of potential nominees from whom he would choose. On January 31, 2017, Trump kept his promise. From his public list, he picked Neil Gorsuch, a judge on the 10th Circuit Court of Appeals, to replace the conservative icon Scalia. By all accounts, Gorsuch was highly qualified, having served on the Court of Appeals for a decade. Indeed, the American Bar Association gave Gorsuch its highest rating of well-qualified. When George W. Bush nominated Gorsuch to the 10th Circuit in 2006, Democrats joined Republicans in confirming him unanimously. Now, with the Senate in Republican hands, a smooth elevation of the president's pick to the highest court might have seemed likely. But McConnell's blockade of Garland had enraged liberal activists, groups, and voters, and many Democratic senators pledged to do everything they could to block Gorsuch's path. The main procedural tool available to Senate Democrats was the filibuster. The 2016 elections had left Democrats with a narrow majority, 52 to 48, which meant that if enough Democrats stood together, Gorsuch would not achieve the 60 votes required to overcome a filibuster. Indeed, on April 6th, a cloture vote to move Gorsuch's nomination to a final vote received only 55 votes in favor, 5 short of the 60-vote threshold. But if the process had ended there, Scalia's seat would have continued to sit vacant. But Senate rules depend upon the preferences of the majority. The next day, McConnell turned the tables on the Democrats by exercising the nuclear option, introducing a measure to change the cloture threshold for Supreme Court nominations to a simple majority. In 2013, Democrats had used the same tactic to quash persistent minority Republican opposition to Obama's appeals court nominees, but only for lower federal court nominations. Now, a majority of Republicans voted to remove the filibuster for Supreme Court nominees as well, paving the way for Gorsuch to be confirmed the next day by a vote of 54 to 45. In the end, the fact that Gorsuch, not Garland, replaced Scalia meant that the court would remain broadly conservative in its overall trajectory, rather than moving to the left for the first time in several decades. In short, the policy consequences of the appointment politics of 2016 and 2017 were substantial. Moreover, the death of the filibuster for Supreme Court appointments seemed to foretell a future of extremist nominees, from both parties. If Roosevelt and his advisors could have looked into a crystal ball and foreseen the confirmation story of 2016, they would have been astounded. The rancor and divisiveness of the politics would have reminded them of Reconstruction, the key experience of their parents' generation. What new civil war could have triggered this partisan battle over Supreme Court appointments? Conversely, Obama and McConnell probably never spent much time studying Roosevelt's brilliant triple play appointments of 1941. The politics of the early 1940s would have seemed as distant from their reality and as irrelevant as life on Mars. What produced the sea change in appointment politics between 1941 and 2016? The question lies at the heart of this book. Answering it requires a journey through American history and politics. It also requires the tools of modern political science. 1.2. The Pelican Problem. Supreme Court appointments have rarely been subjects for works of popular culture, but there is one high-profile exception, The Pelican Brief, the 1992 potboiler novel by John Grisham, which was turned into a movie starring Julia Roberts and Denzel Washington the following year. In typical Grisham style, the plot of The Pelican Brief favors intrigue and action over verisimilitude, but, if you indulge us, the plot is actually instructive for our theoretical approach in this book. In the novel, an oil developer has a project tied up in litigation by an environmental group. The case seems likely to head to the Supreme Court. If the High Court rules in a liberal, pro-environment fashion, the developer stands to lose billions. So what is the poor developer to do? Ask his lawyers to write a really good brief? Fortunately for the novel's readers, a demented legal genius in the developer's law firm suggests a somewhat more aggressive litigation strategy. Simultaneously assassinate 2 Supreme Court justices. The legal genius's elaborate calculations show that their likely replacements will alter the balance of power on the court, leading to a conservative outcome and assuring the developer and his law firm an enormous financial windfall. Of course, we do not endorse assassination as a means of advancing one's legal and financial goals, but as political scientists, we could not help but be impressed by the actions of the legal genius, who performed a social science tour de force. First, he understood the court so well that he could accurately predict how replacing any Supreme Court justice and changing the ideological mix on the court would affect case outcomes. Second, he understood presidential politics so well that he could accurately forecast the likely ideology of a president's nominee based on the president's ideology, the makeup of the Senate, and other relevant factors surrounding a nomination. Third, he understood the behavior of the Senate, interest groups, the media, and public opinion so well that he could accurately foresee the outcome of the confirmation process for any given Supreme Court nominee. We call this analytical challenge the Pelican Problem. In a nutshell, the task of solving the Pelican Problem means predict the likely ideology of a Supreme Court nominee chosen by any given president under any given circumstances. Forecast the outcome of the confirmation battle for any given nominee, and foresee the broad policy consequences of replacing any Supreme Court justice with a new justice. Finally, because we have rather high church tastes in social science, it also means use political science theory to ground the predictions and forecasts. If one can solve the Pelican Problem, one can claim to understand the politics of Supreme Court nominations. Can real-world political scientists follow in the footsteps of Grisham's legal genius and actually crack the Pelican Problem? Remarkably, for a time it looked like the answer was yes. Starting in the late 1980s, political scientists created a simple, clear, and logical theory of Supreme Court appointment politics. Move the median, MTM theory. As a social science theory, MTM is quite elegant. For any vacancy, it makes predictions about the type of nominee a president should select, whether the Senate should vote to confirm or reject a nominee, and the impact of a nominee on the court's decision-making. Unfortunately, it turned out that these predictions fall short when applied to the real world of nomination politics. In a 2016 article in the American Political Science Review, we undertook an exhaustive review of MTM theory's predictions and arrayed them against a great deal of newly available data. We showed that, for nomination politics since 1930, MTM theory does a rather poor job of predicting the ideology of nominees, the voting decisions of individual senators, and the success and failure of nominations in the Senate. These shortcomings, in turn, mean that the theory also does not satisfactorily predict changes in the court's decision-making. To be clear, our point here is not that MTM theory tells us nothing about nomination politics. But these shortcomings do mean that a satisfactory collective explanation of changes in Supreme Court appointment politics over time with respect to presidents, senators, and the court, as well as additional relevant actors, such as the mass public and interest groups, will have to go beyond the narrow confines of MTM theory. So where does that leave us? Most political science books articulate a single theory and provide evidence evaluating the theory's predictions throughout the book. Ideally, one might prefer a unified theory of Supreme Court nominations that solves the Pelican problem for the 90 years from 1930 to 2020. Such a revised theory would have to include a powerful meta-account of American political history, explaining the transformation in appointment politics over these 9 decades, and showing how larger changes in American politics drove the transformation. A single unified grand narrative like this may exist, but if so, we have been unable to find it. Consequently, we pursue a different approach to history and politics. Rather than forge a single master narrative covering 9 decades of history, one theory to rule them all, we deploy multiple mechanisms. By a mechanism, we mean a well-elaborated, casually oriented account of a political phenomenon. We examine several mechanisms because different processes work themselves out over time, intersecting and interacting in ways not really intended or foreseen by actors focused myopically on their own affairs and narrow concerns. Also, because we are committed to the social science school of methodological individualism, our mechanisms focus on human beings, presidents, senators, justices, interest groups, and voters, who have agency and goals, and make choices to advance their goals. We employ this rational choice approach because it usually makes intuitive sense and comports well with quantitative and qualitative data, not just roll call votes, survey responses, and election returns, but also the evidence one finds in diaries, memoirs, recorded conversations and telephone calls, oral histories, speeches, contemporary reportage, investigative journalism, and academic histories, all of which we use in this book. So, in lieu of a single unified solution to the Pelican problem, we present what we believe is a coherent overall account of the history of Supreme Court appointment politics from 1930 to 2020. In a nutshell, we argue that the growth of federal judicial power from the 1930s onward created a multitude of politically active groups struggling to shape judicial policy. Over time, some of these groups moved beyond lobbying the court and began seeking to influence who sits on it. As a result, presidential candidates increasingly pledged to select justices who conformed to policy litmus tests, mostly for Republicans, and diversity demands, mostly for Democrats. Once in office, these presidents reshaped the executive selection system from casual and haphazard to meticulous and effective. As a result, the presidents gained the ability to deliver to the groups precisely what they had promised. The groups also transformed the public face of appointments, pushing the process from a brief and usually closed affair to a highly visible political campaign, mobilizing public opinion via intensive media coverage focused on controversy. In turn, confirmation voting in the Senate gained an engaged and attentive audience, whose presence pressured senators into ideologically polarized voting. The result is a new politics of appointments biased toward selecting and placing consistent judicial ideologues on the court, and only such ideologues. If this account is correct, the implications for the future of the U.S. Supreme Court and for the court's place in the American political system are profound. 1.3. A lens on American politics. A study of the history of Supreme Court appointments naturally draws the interest of die-hard aficionados of the court, like us. But such a study also has the potential to be much more than a chronicle of nominees and justices, a retelling of half-remembered dramas from days gone by. It can, we claim, train a sharp lens on American government and how it functions. A multiple mechanism history of appointment politics offers a powerful device, a laboratory of sorts, for studying the origins, evolution, and consequences of the American governmental process, and a new American politics. 1.3.1. A separation of powers laboratory. These are bold claims. What is their basis? First, Supreme Court nominations constitute the same political event occurring rather frequently and fairly regularly over an extended period, so they allow one to observe and measure what changes in the process and what doesn't over time. In terms of being a regularly occurring event, Supreme Court appointments are similar to, say, elections to the U.S. House of Representatives. Unlike elections, however, every Supreme Court nomination puts America's distinctive governance system, based on the separation of powers, SOP, through its paces. The President and Congress always interact, sometimes vigorously, but interest groups, the media, and citizens can join the interbranch bargaining, all against the backdrop of judicial policymaking. Supreme Court appointment politics do not implicate the entire governmental process. Federalism, for example, plays little role. However, as a device for revealing change and continuity in the performance of the SOP system, and as a venue for thinking about mechanisms and institutions, Supreme Court appointment politics shine. Figure 1.1, included in the print and e-book formats of this book, interrogates our claims about rather frequently, fairly regularly, and extended period. It presents a timeline of our primary 90-year period of study, 1930 to 2020. This era saw 54 Supreme Court nominations, beginning with Herbert Hoover's selection of Charles Evans Hughes as Chief Justice and ending with Donald Trump's nomination of Associate Justice Amy Coney Barrett. The nominations span 9 decades and feature the involvement of 15 presidents and 29 senates. A table containing information on each nominee appears in the appendix online. In the figure, the lower graph gives the name of each nominee and the year of nomination, the name and party of the nominating president, and whether the nomination succeeded or failed. So it is a handy overview of the whole history. The top part of the figure shows the incidence of nominations, with a thin vertical bar indicating the date of each nomination. On average, a nomination occurred about every 20 months. The figure reveals, however, that many periods saw flurries of nominations, while others witnessed dry spells for nominations. One 5-year gap occurred after Cardozo's nomination in 1932, coinciding with Roosevelt's famous confrontation with the court. The longest dry spell occurred between 1995 and 2004. From our perspective, this unusually long hiatus is not so concerning because both presidents who served in this period, Bill Clinton and George W. Bush, made nominations. More problematic were the sparse nominations of the 1970s. Not only did Jimmy Carter have no opportunity to alter the court, this period saw a dramatic growth in the number of interest groups, both generally and with respect to Supreme Court nominations. Nonetheless, on average, Supreme Court nominations occurred with sufficient frequency that we can conclude that appointment politics constitute a suitable laboratory for studying the evolution of the separation of power system. 1.3.2. The New American Politics. Before entering our separation of powers laboratory, it is helpful to review the big changes that transformed American politics during the last half of the 20th century and the first decades of the 21st century. These changes helped drive the transformation of Supreme Court appointment politics. There are many ways to tell a big-picture story about the emergence of the new American politics. Our version naturally looks ahead to appointment politics, which affects what we emphasize and what we downplay. For example, war has been a huge driver of political change, but it plays little role in our story. Similarly, the rise of income inequality has exerted a profound effect on American politics, but is not central to our story. Finally, race and identity politics make an appearance, but they are somewhat secondary to the larger political story about changes in focus and preferences that we tell. Our rendition of the big story focuses on 5 changes. They are: 1. The growth of government and the concomitant rise of a powerful judicial state. 2. The stunning proliferation of interest groups, activists, firms, and wealthy individuals vying to shape government policy, including federal judicial policy. 3. The capture of the political parties by interest groups, activists, and issue enthusiasts, leading to an astounding ideological polarization of elites. 4. The remarkable rise in the frequency of divided party government, and 5. The emergence of a new electorate, one better sorted into parties by ideology, but retaining huge disparities in political knowledge between the most and least engaged citizens. Each of the 5 changes was important in itself. Together, they interact to create a new politics of American governance, and a new politics of Supreme Court appointments. 1.3.3 The growth of government and the rise of the judicial state. Figure 1.2 describes a revolution in American government and society. It depicts per capita federal expenditures in real terms, from 1900 to 2020. In 1900, the federal government spent about $160 per person, using constant 2015 dollars. As late as 1930, the beginning of the period we study, the federal government expended only about $400 per person. The reason for the tiny numbers is simple. In practical terms, the federal government did almost nothing. The military was puny, social insurance programs almost non-existent, and public improvements few and far between. But this situation changed dramatically, and growth in expenditures continued its upward trend even after the sharp spike generated by World War II. Figure 1.3a displays a perhaps more subtle trend. It shows the number of pages in the U.S. Code, the omnibus compilation of federal statutory law, which provides a rough measure of the size or volume of federal law. As shown, the Great Depression, 1929 to 1939, doubled the volume of law compiled in the U.S. Code, but that was just the beginning of a continued and ever-increasing upward trend. Figure 1.3b depicts the percentage increase in pages from one revision to the next, and shows that the change between the 1930s and 1940s was by far the largest, but also notable were surges in the 1970s and the 1990s. This explosion in lawmaking translated into a tremendous increase in federal programs, all of which required funding. By 1940, the New Deal social insurance programs had almost tripled federal governmental expenditures in 10 years, to about $1,200 per head. This increase involved a titanic struggle between President Roosevelt and Congress versus the Supreme Court. As remarkable as the New Deal was, the next half-century saw an even more jaw-dropping change as the volume of law and expenditures rose hand in hand. Between 1940 and 1965, the U.S. Code doubled in size and per capita real expenditures quadrupled. Between 1965 and 2010, the Code nearly quintupled in size, while expenditures nearly tripled, rising to just over $12,000 per capita in 2015 constant dollars. In other words, between 1930 and 2010, real per capita expenditures increased more than 30-fold. The volume of federal statutory law, as measured by pages in the U.S. Code, increased 15-fold. Changes of this magnitude are not evolutionary, they are revolutionary. With the federal government expanding at this rapid rate, Congress turned to the executive branch to implement these new programs, thereby giving rise to the administrative state. As a simple measure of the size of the administrative state, consider Figure 1.4, which shows the number of pages in the Federal Register, the official record for agency rules in the U.S. federal bureaucracy.
Sample complete. Ready to continue?